Mr. Riley.
Court, my lady, my lord. As a preliminary matter, there is a reporting restrictions order.
I was going to discuss that with you all first of all. Yes, Mr. Contefarley.
It says on it that it's valid until a final order's been made. A final order has been made, but obviously the matter is under appeal, so it's a little bit of uncertainty.
Could you? Yes. Well, I think we were both a bit uncertain also. Could you just help us, because obviously the judgment at first instance appears to be a public judgment in that everyone is named on the front sheet of the judgment, and there's a neutral citation order, so presumably it's available to the public with everybody named, including the child, but not the clinician.
Not the clinician.
So is that our current position?
Yes, it is.
All right.
And there isn't any challenge to that.
No challenge to that. So everybody's, so just so that we're clear, because we've got live streaming on, I see, quite rightly, the child can be named, the family members can be named, but at this stage of the proceedings, none of the clinicians may be named.
My lady, you mentioned this live streaming. For the purposes of this appeal, should we therefore not be referring to the names of any of the clinicians? Or
no, don't. That's what I'm saying. The clinicians cannot be named for the purposes of... So do not name the clinicians, please. Mr. Farmer.
Well, I think it covers I think the order originally covered the guardian.
Yes?
My lady, yes, the order originally covered the guardian. As I understand it, that was to cover the guardian's position while she was making investigations at the hospital. And so the guardian's position is that as long as, if this comes to an end, she's content to be named, but if it continues and she may have to go back to the hospital to make investigations, then we would ask for her name to continue.
Well, Mr. Quintavalli, that sounds very sensible, doesn't it? Should we say that for the purposes of today's hearing that the guardian should not be named, because obviously we don't want to in any way prejudice anything that may happen after today? Everyone content with that? Is that clear, Mr. Farmer?
Very clear, my lady. Thank you very much indeed.
My lady, for some reason I was under the impression that this wasn't going to be live streamed, and
well, if people haven't, well, we had Ms. Kitzinger contacted the court today, wanting to know if it was live streamed, and my understanding was that given that this is a public hearing, subject to the reporting restrictions, that was appropriate. But I'm very happy to hear any submissions, and we'll consider them, of course, because there is a switch which I can flick which will stop the live streaming if all the parties feel it's not an appropriate course to adopt.
my difficulty is only this, and it's not. It would otherwise be an appropriate course to adopt, but there are a great many clinicians which are mentioned as having provided evidence to the court, and I'll be needing to take the court to have a look at the nature of that evidence.
We haven't got the original bundles, and this is an application for permission. I mean, we haven't got all the trial bundles, Mr. Quintavalli. Nor would we expect to under the rules. You know yourself, because I know how very experienced you are in these cases. But you know yourself that the CPR provides a limited number of documents for the purposes of considering a permission to appeal. And as you know, and I know your instructing solicitor also knows, we deal with these matters as oral permissions because of the grave, and with two Lord or Lady Justice because of the very serious nature of them. But that doesn't turn them into a different animal, if I might put it like that.
No. But the only evidence which I intended to look at is some of the evidence which is contained in the supplemental bundle. That's not the full trial bundle. The full trial bundle had 5,000 pages of medical evidence. The supplemental bundle's got 150.
Well, it arrived, I don't know about my lord, but mine arrived at about midday. So for my part, I haven't had an opportunity of looking at it.
Yeah, and the only difficulty is this. It's just that a lot of the clinicians whose evidence is referred to, I don't believe had been assigned any letter, because I could be wrong about that, and I'm not going to be able to name them. It may be difficult.
Is it your submission that the matter should not be live streamed? Because I'm reluctant not to live stream it in the interests of transparency in these difficult and tragic cases. I mean, could we not refer by page number and to
Yes.
this is a paediatric neurologist
Yes.
or whatever at page whatever and refer us to the paragraph?
Certainly.
And may feel a bit clumsy, and I'm sorry if it interrupts your flow, but I think, for my part, subject to any further submissions by anyone, and my Lord's view, I would prefer to deal with it that way than to stop live streaming.
My lady, I agree. Can I just check that there was a statement from the consultant intensivist who sits behind me that was provided to the court in accordance with your direction?
accordance
Have you
with
had
my
a chance to see that? Because I've got hard copies if my lady
No.
needs to have that.
I can just find it. I have it and I've read it. Yes.
Right.
Yes, I have it. It's quintifolia. Obviously, you've got that. That's in pursuant to the order I made on Friday. Yes.
I have no submissions to make about live streaming. Content with my lady's approach.
So, can I just check? Your lay client has had the father has had an opportunity of reading that update, I hope.
Yes, he says he's had a quick read this morning.
Good, I'm glad about that. Thank you very much. Now, Mr. Quintivalli, as I'm sure you're aware, we've had an opportunity of reading the judgment, the respondent statement, the chronology, grounds of appeal, and your lengthy skeleton argument, for which I'm very grateful.
My lady, my lord, just by way of introduction, because we seem to have missed this important stage. I appear for the father, Mr. Gregory. Indy's mother is not present, but she's supporting the father.
Understood.
My learned friend, Miss Sutton, King's Counsel, appears for the
Sutton.
trust, and Miss Scott appears for Indy's guardian.
Yes.
This is an appeal against two orders, decisions made by the learned judge. The first is the order of the 3rd of October, refusing the father permission to appoint various experts. That order's on page 35 of the core bundle. And the second order is a final order in which the decision to withdraw life-sustaining treatment was made. That's at page 39 of the core bundle. The judge made it clear that he would keep under review the decision not to appoint experts, and as such, it wasn't a final decision. It was one which was subject to revision, and it's one that, in my submission, should have been revised. It was obviously not open to us to make a new application in the absence of no change of material circumstances in the matters before the court.
Well, you could have made the application consequent upon anything that you achieved during cross-examination.
My lady, I'm mindful of past experiences where I've renewed applications and had been threatened with wasted costs and more.
Not by
my
this
lady.
court.
Not by this court, but my position is that it was open to the judge. It was certainly the nature of our submissions at the final hearing, and it was the nature of our position statement at the final hearing that this matter needed further experts. It was implicit in all of our submissions that this wasn't a matter which could be resolved on the basis of the evidence before the court. But nonetheless, that is something that the learned judge pointed out and observed, and it's in response to that I made that brief submission. this is not a case, perhaps in difference to many others, where I stand before the court and say that the judge came to the wrong conclusion. Mr. Justice Peel may well have been right to conclude that Indy's best interests required the cessation of all further life-sustaining treatment. And he may have been right in the other conclusions that he came to. But this appeal is made because he had no proper basis to come to the conclusions that he did on the evidence that was before him. If he was right in spite of the evidence, not because of the evidence before the court. And ground one argues that the evidence before the court was insufficient to satisfy the anxious scrutiny requirement, the obligation that the judge had when dealing with a case involving life or death decisions. And that this evidence was insufficient for a court to be able to arrive at a proper determination and also to satisfy, therefore, its Article 6 obligations in this regard. Ground two instead argues that the hearing was procedurally unfair, principally in that it breached the equality of arms requirement that's required under common law, but especially under the Strasbourg jurisprudence. The failure of the court to permit Mr. Gregory to instruct his own pertinent experts made it effectively impossible for him adequately to challenge the medical evidence marshalled by the trust, and therefore breached his right to a fair trial. I am mindful, and I'm grateful to the court having reminded me that this is a permission hearing, and there's an awful lot of medical evidence, and also case law before the court, and little time to cover it properly in a permission hearing. Obviously, there's no need to. But it's there, and mindful of the time constraints, I don't propose to take the court to the majority of the evidence or the authorities unless invited to do so. I also don't propose to repeat what's in the skeleton argument, though I shall expand on some of the points made, particularly in the light of the objections raised by my learned friend.
The objections? What objections?
I'm sorry?
What objections?
In the reply, there have been
Oh, I
various
see, sorry.
responses to
Yes.
our arguments.
Yeah.
Also, at the outset, I would like to say that there's an element of the judgment which is not under direct appeal, but it permeates both ground one and ground two, and this is the proper test that a judge is required to undertake when considering whether to appoint experts. And the proper test we submit is Section 13 of the Children and Family Act 2014. That's the requirement in children cases for determining whether an expert should be.
You're going to have to remind me of that, Mr. Darling.
Yes.
Is it
In
in
fact,
the
I've used the
bundle?
word remind, pretending that I know Section 13 and I've just forgotten, which of course isn't true.
Yes, so it's page 8 of the authorities bundle. We have Section 13 of the 2014 Act.
Yes. That's then reflected into the Family Proceedings Act, Part 25, isn't it? Or that is, this is 2014.
It is, and it's Rule 25 that was then relied upon by the judge, and he said he was quite sure that this applied. The problem is that Rule 25.4, to which express reference was made by the judge, says that it's a short provision, but it says at the bottom, in parentheses, provision relating to the control of expert evidence in children proceedings is contained in Section 13 of the 2014 Act, and 25.41 says this rule applies to proceedings other than children proceedings. And we say this was a children proceeding, And
Mr. Quintavali, this wasn't argued before the judge. It's not a ground of appeal. And in fact, the judge, I think, specifically in his judgment, deals with this at paragraph 18. Where a tentative query was raised as to whether proceedings were family proceedings. And the judge went on referring to FPR and Section 32 and so on, and the Senior Courts Act to conclude that Part 25 applied. Now, there's no appeal against that, and I can't see any mention of Section 13 or whether or the application. So where does that help me with this application?
well, my lady,
And what is your what's your submission about this? Are you seeking to adduce another ground of appeal? Or are you?
my submission is that this was, well, my first submission is that no mention is made in the judgment of Section 13, but it was certainly raised by myself before the judge. It was not an argument which evidently found favour.
In fact, it sort of looks like it wasn't pursued. Is that not right? Did you argue it out?
There wasn't a great deal of discussion before the court as to what the correct rule was. My submission was simply that it was Section 13. Other people suggested
What do you say the test is then? What were you saying the test is? Were you saying it was necessary or reasonably required?
the test is necessary. It's a very similar test to 25.4. However, it has other factors which need to be taken into account. The only significance which I want to rely on is that Parliament has provided for the restriction of control of expert evidence in children proceedings by this particular statutory provision, and I will have something to say to this about this when I deal with this matter, but I just wanted to highlight it at the outset. It may be that not a great deal hinges on this, because one way or the other, whether it's through the family proceedings rules or whether it's through the Children and Family Act, there has been parliamentary intention to regulate this. But the test is different, and it is a matter which I raised before the court below, and it is a matter which it's proper that this court should consider. And I'm not suggesting that it is necessary, but if it is appropriate to amend the grounds, then an application will be made, but it's not the ground we're relying on. It's not a challenge to the wrong test.
So you accept the test is the judge applied the correct test?
Well, I can't accept that the judge did, but I accept that it wasn't in our grounds of appeal, and I'm. It is a more comprehensive test that's set out in the Children and Families Act, but it's not the central point of the argument that I'm making.
Well, let's leave it there for the time being. We understand your point.
The starting point of this case under ground one is an acceptance by everyone concerned that in these medical situation is extremely complex. She has a very rare genetic mitochondrial disorder that has only been identified in very few cases. And this does make this case rather different from the majority of cases which the courts have had to consider. The judge, in the face of this complexity, adopted what he termed a holistic approach. He didn't think it was appropriate or necessary, as he put it, to compartmentalize in these individual medical difficulties, but rather to look at the case in the round. But we say that this holistic approach does not mean substituting facts and analysis with a broad brush impression. And the judge briefly summarizes his balance sheet in paragraph 44 of the judgment. But we say that in short, that the conclusions that he came to there are not ones which it was appropriate to come to on the evidence before the court, or could have been come to on that basis. First is the question of significant pain. We had evidence from a nurse with managerial responsibility. This was some rather ad hoc evidence, which the judge himself wanted to call at the end of the hearing. But there wasn't a great deal of evidence about Indy's suffering of pain or discomfort from the trust. Not much of this evidence was volunteered, and it was perhaps for this reason that the judge thought it important to try and find out more about this at the end of the hearing. Nonetheless, we say that evidence was not appropriate evidence upon which to come to a conclusion of pain. The judge found that Indy's condition was incurable, but and that may be true as far as D2L2 is concerned, though there is evidence that it might be successfully managed by 3 experimental treatments, which Indy's undergoing. But that's not the case with other, and this isn't controversial, this isn't the case with others of her comorbidities. The tetralogy of Fallot, which is the heart condition, is curable. It takes an operation which may or may not be appropriate to perform, but it's certainly curable. And
is it your case then that the recent meeting, the 8th, 9th of October, from the external cardiac experts, that whilst it in other circumstances would be treatable, given the grave illness of this little girl, they would all refuse to treat her? It's not in their interest to treat her. Is that challenged?
yes, it's not clear on what basis there was the decision not to treat was made. It's
sorry, I'm just very anxious to make sure I don't get wrong about this. I thought that on the 4th of October there was a joint cardiac conference in Birmingham, and that by virtue of the judge's order, what they were going to be asked and how it was going to be dealt with included agreed questions between the parties. So presumably you agreed those questions, Mr. Quintavalli, and that the result of that joint conference was that her current presentation wasn't likely to be materially caused by her heart condition, and that the Birmingham Children's Hospital expert unit weren't willing to offer any treatment. Now, is that challenged now?
No, that isn't challenged.
So the position currently is that so far as her heart condition is concerned, in another child without D2L2 and the other comorbidity, it would be treatable, but in her condition, because of her general condition, it wasn't in her best interest to treat it. That was my understanding.
Yes, so essentially those were the 2 questions. Was the heart condition materially responsible for Indy's presentation?
The answer is no.
The answer was no. And the second one was, would you be prepared to treat her? And the answer was no. But we don't know why.
What's your challenge to that?
Well, the challenge is this, that we don't know why they weren't prepared to treat her. What were the reasons? There seems to be a suggestion that it's because she didn't have a very great life expectancy, so it wouldn't be appropriate to treat her. But more to the point is that there was no opportunity and to cross-examine any of those people who came to that conclusion. And there was no other cardiac specialist, either a cardiologist or a cardiac surgeon, who was giving evidence to the court, who would have been able to expand on that question. So, to a certain extent, we were left none the wiser. And that point deals with cardiology evidence. There was concern about Indy's hydrocephalus, but there was no neurologist before the court who could say anything about the hydrocephalus, whether or not, as Indy grows and develops, whether there could be some improvement expected of her brain, or whether things were going to stay the same, or whether they would get worse. I stress there's no evidence from a neurologist. There was other evidence, but none from a neurologist dealing with that issue.
But we do know that she's too ill to have an MRI. So a neurologist would not be able to carry out the gold standard test of an MRI.
But there are other ways of assessing how what sort of development might be expected or not, and the fact that the question as to whether Indy was not able to undergo an MRI is one, again, that it wasn't possible realistically for Mr. Gregory to challenge. This court has approved MRIs in the case of people who have been diagnosed as being brainstem dead, who one would imagine are much more clinically unstable than Indy was.
I don't think it's helpful when none of us are
No.
medical practitioners to start trying to compare about the quality, whether you can have an MRI with brainstem death and a mitochondrial
Absolutely.
ventilated 7-month-old baby.
Absolutely, my lady, and that's the problem. None of us are medical practitioners, and I certainly not. And
So you challenge whether or not the evidence is correct, when the clinical evidence that she is too unwell to have an MRI is you challenge that?
The challenge is this, that the evidence before the court, such as it was not evidence which was able properly to inform the court, such that the court could perform an anxious scrutiny test on that evidence. There was evidence from intensive care consultants. There was evidence from respiratory consultants. There was evidence from a paediatrician with an interest in mitochondrial diseases, but there wasn't the evidence that would have been needed properly to inform the court about the broader range of concerns, and actually the very specific concerns that this case raised. There wasn't evidence from a cardiologist that Mr. Gregory would have been able to cross-examine on why the tetralogy of Fallot is not responsible for Indy's presentation. There was evidence from other clinicians that in various forms was before the court that it was expected that Indy's heart condition would contribute. And that was evidence that was before the court. So it's difficult then when a clinical team at another hospital says that there isn't any evidence for us to be able to understand why there's this divergence. We didn't have the evidence from mitochondrial experts in this particular condition. And there was an expert available. Professor Mulhausen did make himself available to, I don't think there's any problem in mentioning his name. He's not a treating clinician of Indy's. He's one of the, in the field of a very restricted disease, he's one of the world experts, one may say, on this. He's treated a number of children with this condition, and he would have had an important contribution to make. He was available to make that contribution. The judge didn't think it was important.
Well, no, the judge didn't think it was necessary.
Didn't think it was necessary to this. The I do want to. We also had evidence, and the judge made a finding that there was minimal engagement with the world. But again, that wasn't evidence which was informed by any neurologist or even by a nurse with direct involvement in Indy's care.
Wouldn't that be something a paediatric intensivist would be able to comment on? I mean, this is what they deal with day in, day out, paediatric intensivists.
Well, it would have been
what
something.
would you want more than that?
It would have been something that a paediatric intensivist could have usefully commented on, and the judge did give permission to Mr. Gregory to instruct a named paediatric intensivist, and who happened also to be a consultant in paediatric respiratory conditions. Unfortunately, he simply wasn't available in a very short time before the hearing to accept the instructions. And unfortunately, even if he had been, the legal aid which had been granted shortly before the hearing wasn't able to be extended in time to be able to permit that instruction. The sort of adjournment which would have been necessary wouldn't have been very long. The official application asked until the 20th of October to prepare instructions, but in my oral submissions, I believed that we would be able to obtain instruction if the trial was adjourned just simply for another week. The reason a little bit more time was needed is we hadn't yet identified the precise pediatric cardiologist who could have given evidence, but the other experts had been lined up. This isn't a case where the parents are making an application in the abstract to say, well, we want permission to instruct unnamed experts. There were 3 named experts that had been identified. They would have been able to prepare reports, but not within 3 days. And before turning to the nature of the general challenge on this evidence, I want very, very briefly, but it's important, just to look at the sort of approach which the courts give in these sort of cases, and a body of case law has built up. And just very briefly, to run through principal cases which come to mind, and they're all in the authorities bundle. The case of Guard I mentioned in the skeleton argument, and I don't need to make points there. We have a recent case, Alderhay and D, in which 2023, in which there was oral evidence from an intensivist, a palliativist, 2 neurologists, gastroenterologist, physiotherapist, nurse, a written second opinion from 2 other neurologists, and a 4-day hearing, after which Mrs. Justice Morgan adjourned to let the father instruct 2 experts, an intensivist and a neurologist, and there were 2 further days of hearings and submissions, 6 days in total. The Pippa Knight case, which was PVS caused by a rare condition, where the only issue before the court was whether she should be allowed to go home to die. This was a 5-day trial, and for a great many experts, and the mother was given permission to instruct 2 experts of her own. The Alfie Evans case was a child with an unknown condition in that case as well. That was a 7-day trial. The parents had the ability to instruct 2 experts of their own. But even in cases involving hypoxic injury, where the nature of the injuries was clear, the courts give more time. In the Isaiah Hastrup case, it was a 3-day hearing. The parents were given permission to instruct 2 experts. The Tafida Rakib case was a 5-day trial, which was divided up into a judicial review and a best interest hearing. But the best interest part of the proceedings was a 3-day hearing, with the parents able to instruct their own expert and put in evidence from the treating team of another hospital. The Riem case, which was a baby who'd been diagnosed as being brainstem dead following hypoxic injury and diagnosed according to the properly followed protocols, that was a 3-day hearing. Walter Fixler, another case involving severe hypoxic injury, the guardian was given permission to instruct an expert in any relevant discipline that the guardian saw fit, and the parents were given permission to instruct a paediatric respiratory consultant, but the judgment records that they chose not to seek an independent neurologist, but presumably they would have been able to if they wished. That was a 3-day hearing. The present case is probably the most complex of those medically involving an exceptionally rare condition, and also concerns a child who's plainly in a much better state than Charlie Gard, Alfie Evans, Pippa Knight, Isaiah Hastrup, Tafida Rakib.
I really don't think it is helpful to start comparing child against child, Mr. Woodfarley.
Well, I wish to...
certainly don't think it's appropriate for us to start to say that these children that are desperately ill, one child's more ill than the other,
Well,
one child suffered more than another. I really don't think that's helping me.
I'm not making any comment on how much they're suffering, but on the complexity of the issue.
Well, that would require detailed examination of the medical situation of each of the children. What you rightly emphasised, and I completely take on board, is that this baby has a highly unusual, rare mitochondrial condition, made more complex by other comorbidity. In particular, you've emphasised her heart condition. Absolutely understand all of that.
My lady, well, I take 2 rapid steps back from I concluded what I'd wanted to say there, but the only point was this, that the court, in giving effect to the anxious scrutiny requirement, there is, and my submission need go no further than that, but there is, the courts have typically given more time than 1 day, and typically have allowed the parents to instruct experts, and that's all that the father was asking in this particular case. The parents had asked for a 3-day hearing, and they had asked for the possibility to instruct experts. And there's another reason why this was important, and this comes to the Family Procedure Rules / Children and Families Act point, which I'm going quickly to come on to. And it's an important point. And it's this. There wasn't, in fact, any formal expert evidence before the court at all in this case. None. And this was a matter which was raised at the directions hearing. It was made clear by the father that he expected any evidence that was to be relied upon to be presented in the form of witness statements, with the deponent being available for cross-examination. And the trust indicated they would be relying on 4 witnesses. And those 4, and various witness statements were before the court, and properly before the court.
Could you just remind me of the specialities of the 2 of those 4 that you didn't require for cross-examination?
So one of them that wasn't required was a paediatric consultant with inherited metabolic disorder interest. And the other one was a paediatric respiratory consultant.
And were they from this trust or from outside trusts?
They were from the trust.
Thank you. So then you didn't. Then you cross-examined two consultants.
Yes, and the first one was cross-examined quite extensively.
Dr. E.
Dr. E. But this has to be said. It was made very clear from the beginning that I had very limited time. As it was, the hearing went on until 6:25. A decision was made to concentrate on two of the witnesses before the court, but not because the others would not necessarily have been useful, but because within the day that had been allotted, I had to make a decision as to how best to use my time. If there had been more time, perhaps there would have been more cross-examination, and the other witnesses would have been examined. I want my lady to turn to one important question, which just illustrates the sort of difficulties that we had. And this is a question relating to whether or not Indy had diabetes insipidus. And this was an important question because as the evidence had been presented before the court, diabetes insipidus is a serious condition, and it's indicative of progression of damage to the brain. So if Indy had acquired diabetes insipidus, this would be a very concerning and serious development. And that Indy did have diabetes insipidus was a matter that that the trust did put forward. In fact, it formed part of its premise in its care plan, which can be found on the compassionate care plan dated the 9th of October, which can be found on page 42 of the core
Yes, I'll have it. Thank you.
bundle. And we see there on the first page, about right in the middle of the page, it says, she has also developed central diabetes insipidus, which is a lack of brain-generated hormone which controls fluid and salt balance. This implies further degeneration of her brain. She has never needed this amount or length of support before. And after the hearing, the father, and this we can see from correspondence that's been included in the supplemental bundle between the father's then instructing solicitors, then solicitors Moore Barlow and the trust. The father had a conversation with consultant endocrinologist, pediatric endocrinologist from the trust, who indicated to the father that this is the father's recollection of the conversation, that in fact the trust had been mistaken in its diagnosis of diabetes insipidus. And this confusion was caused for various reasons to do with excess urinary output, but an explanation was given. The solicitors wrote to the trust asking for, this was on the 11th of October, asking for clarification of this, if this was true, because this was an important matter which had gone before the court. And the upshot of that was that the trust, I assume, communicated with the court to update them on the condition. And a revision we don't have the draft judgment here, but a revision to the judgment was clearly made, and we can see this on paragraph 10 of the judgment, page 49 of the core bundle. Learned friends asking court to look at paragraph 4 as well.
No, 3.
Sorry, 3. Yes. So maybe we can start at 3. At the time of the hearing before me on the 9th of October 2023, there was also diagnosis of central diabetes insipidus, which is a lack of hormone made by the brain. Following a review by a consultant in paediatric endocrinology and diabetes on the 11th of October, before my judgment was handed down, it was confirmed that diabetes insipidus was no longer present. The consultant had confidence in the previous diagnosis and stated that this is a picture frequently seen in children with progressive brain failure. The consultant confirmed that IG's brain function continues to deteriorate. And 10 says essentially the same thing. I don't need to take the court there. The problem which is recorded here, as far as my client's concerned, is that we have a consultant who hadn't been giving any evidence to the court, confirming that diabetes insipidus was no longer present, but now saying that it had been present before. Parent had no way of challenging or that particular consultant, nor of challenging the suggestion that this is a picture frequently seen in children with progressive brain failure. This wasn't part of the evidence before the court. The consultant confirmed that IG's brain function continues to deteriorate. Well, that's all well and good, but that's not evidence that the father had any means of testing, and nor did the court. The court accepted a letter which had been sent, not from the consultant, endocrinologists themselves, but had been forwarded as part of another letter. And then that becomes part of the reasoning for the judgment. My lady, my lord, I now want to look at what the law has to say about the instruction of evidence of experts and how hearsay evidence is treated. The first case to look at very briefly is the case of the Crown and Maguire, Criminal Appeals Report, 1985, Volume 81. This is at the beginning of the authorities' bundle, page 16. This was a case about arson in a hotel, and the expert who prepared the report...
Sorry, you'll just have to slow down. We're my list of contents bears no relation to either the tabs or the page numbers. I'll just have to find it.
I've got
According to my bundle, it's tab 4.
4.
Yeah, but as my tabs start at tab 13. Just give me a moment. Right, first case. Let's try again. Right, found it. Thank you very much, Mr. Quintifani.
This was a case involving conviction for arson. It was a case in which expert evidence had been commissioned to work out where the fire had started. Unfortunately, the expert who had prepared the report died before the hearing, and the judge decided at the hearing that his evidence of fact could be admitted, but not as opinion evidence, because he wasn't there for that evidence to be tested. And that decision was upheld by the Court of Appeal, which looked at all the authorities, the relevant authorities in civil law in particular. And the conclusion, the bottom line point is this, that the common law does not permit opinion evidence from an expert witness who is not before the court for cross-examination.
So have you got the list of treating clinicians that you required to come and give evidence?
Well, we'll have a look at that when we look at the provisions of Rule 23.3 and how the disapplication of the Civil Evidence Act of 1995 works in these sort of cases, because the requirement is not on the father to provide a list, but it's on the...
No, I appreciate that, but there was extensive directions hearings, and I'm just trying to understand where the arguments about CPR and hearsay evidence fitted in, and in turn fitted into the extensive directions hearings where decisions were going to be made about who would be called to give evidence and who would not. I'm just trying to put the jigsaw together.
At the directions hearing on the 27th of
September.
It was confirmed that the Trust would be providing evidence from 4 experts and from 4 clinicians. I'm not going to call them experts, and that's the evidence they were intending to rely on. I perhaps don't need to take, I gather, lady is very familiar with the effects of Rule 23.3 of the Family Procedure Rules and the disapplication of the Civil Evidence Act. But Rule 23.3 is there. Rob? The Rule 23.3 disapplies, sorry, take a step back to look at Section 2 of the Civil Evidence Act. Where a party wishes to rely on hearsay evidence,
Perhaps I'll just pass the relevant family proceedings rule to
I've got it.
Have you got family proceeding rule? You? Yes, I've got it up. My lord has got it on screen. I've got it in the red book. If you lost something, Mr. Quinterballi, take your time.
yes,
Always guarantee it'll be underneath some other document.
I've got on page 11 of my of the authorities bundle, I've got part 23. And the starting point is Rule 23.2, which says that where a party intends to rely on hearsay evidence at the final hearing, and either that evidence is to be given by a witness giving oral evidence, or B, that evidence is contained in a witness statement of a person who is not being called to give oral evidence, that party complies with Section 2.1a of the Civil Evidence Act by serving a witness statement on the other parties in accordance with the court's directions. And that evidence, then 23.22, says that where this 1b above applies, so where the evidence is contained in a witness statement of a person who is not being called to give evidence, the party intending to rely on hearsay evidence must, when serving the witness statement, and
inform the other parties that the witness is not going to be called to give oral evidence and give a reason.
sorry, I just have to turn over the page. Yes, inform the other parties and give reasons why the witness will not be called. Well, we didn't have any of that. And this is the answer, the short answer to the long list of various clinicians, which my learned friend cites in her reply and says, look, there was all this evidence before the court, but the problem is that it was all hearsay evidence, and no notice was given that the trust was going to be relying on all this hearsay evidence. And so, and the result of that is that the father didn't have an opportunity to try and respond to any of that. He didn't have an opportunity to try and adduce his own experts, and there was certainly no opportunity properly to prepare for a cross-examination as a result.
Sorry, Mr. Goodall, I do beg your pardon. I'm getting confused about what you're referring to. I just want to make sure I haven't misunderstood you. When you say there was a lot of hearsay evidence, what exactly are you talking about? Do you mean the witness statements of the clinicians? Do you mean that's hearsay? Is that what you mean?
No.
No. Okay. I'm glad I asked, because I don't know what you mean in that case.
So an example of the sort of hearsay evidence which would be these results of these joint cardiac conferences, which or letters from various clinicians which are referred to in various witness statements, or which have somehow found their way into the evidence.
You mean documents that witness statements are referring to? Certainly in the civil procedure rules, that's, I don't know about the family procedure rules, but in the civil procedure rules, you can do that.
Yes, and you can do that. You can do that here in the family procedures as well, subject to what Rule 23.2 says, subject to, and 23.2 says, subject to witness statement being provided, explaining what evidence is going to be relied on and why that witness will not be called to give evidence. And that's what wasn't complied with. There was no, in most of these cases, and this goes back, and I'm not wanting to make comparisons, but just to say these issues perhaps haven't arisen in the past because there's been a great deal of evidence directly before the court in the form of witnesses available for cross-examination who've provided witness statements. In this case, that wasn't the case. We had 4 witnesses available before the court, but none of the other evidence had complied with these Part 23 requirements.
I just want to make sure I'm not misunderstanding you. When you say none of the other evidence, you're talking about documents exhibited to witness statements of those 4 clinicians. Or do you mean other evidence?
Yes, I mean the documents exhibited to the witness statements.
And they were all witness statements who were made available for cross-examination. They may not have been cross-examined, but they were made available. I'm not trying to cross-examine you, Mr. Grenville. I just want to make sure I'm not missing something.
So if this is exactly the point. So Rule 23.2 1b talks about evidence contained in a witness statement of a person who is not being called to give evidence.
But these people are being called
yes.
to evidence. So it's 23.21a that applies, and 23.22 doesn't apply if 23.21a does apply. Unless I've misread it.
My lord, I don't think you haven't misread it. The evidence that was before the court, a lot of it was attached to the various witness statements of the witnesses giving evidence. But the problem that we have goes back to this more fundamental problem, which is related to this evidence being opinion evidence and not factual evidence. The hearsay evidence, which is dealt with in Rule 23.2 regards all evidence, it's not making that distinction. But the father's concern in this case is that the court was relying essentially on expert evidence of witnesses who hadn't been admitted as experts. And whether one looks at Rule 25.4 or whether one looks at Section 13 of the Children and Families Act 2014 as the source of that power, the court is obliged, it is not able to admit expert evidence in any form unless it's been specifically admitted by the court. And the procedures are then in normal cases. Now, I accept that there will be emergency cases where the court is obliged to deal with matters very quickly and there isn't time to go through these formal procedures. But this, in my submission, wasn't the case here. There wasn't any expert evidence admitted, and yet the judge relied on all sorts of evidence. For example, I gave the example of the consultant endocrinologist. Evidence which made its way before him in all sorts of ways, but none of which had been formally admitted as expert evidence. And that put the father in my submission at a great disadvantage. At the end, I just want to bullet point, and I'm not going to go into any detail, but what we said were the areas of uncertainty at the end of the evidence which was properly before the judge. And we say there was no formal expert evidence, and so this was a deficiency because it meant that that there was no opinion evidence which was properly before court. But the areas of these, just very quickly, bullet point. We have the nature of Indy's genetic disease and the implications for her prognosis. We have the question of the efficacy of each of the 3 experimental treatments given to Indy and the implications for prognosis. We have the question of the cause of Indy's clinical deteriorations, which is a very important issue, which needed, clearly needed in my submission.
Could you just, before you go through your list, I'm just noting it down, but can I just note next to that, does the father accept that Indy is deteriorating as set out in the update of the clinical assessment, which I emphasise clinical assessment, not purporting to be an expert assessment, it's a clinical assessment. Does the father accept that?
I don't believe the father does accept that.
He doesn't accept the various measures show that she's deteriorating.
The father does accept that Indy is very fragile and does accept that she has a limited life expectancy, but he doesn't accept that that the situation is anywhere near as bleak as has been painted by the trust.
Thank you. Sorry to interrupt you, I just wanted to be clear about that.
We were on to the cause of...
So we've got the efficacy of the experimental treatment, we've got the cause of her clinical deterioration, which is not accepted as happening.
Yes, and the first point was the exact nature and type of Indy's genetic disease. And this... If I could look at a letter on the supplemental bundle, page 58 and 59, I'm not going to refer to very much evidence, but it just shows the sort of...
Sorry, 50?
58 and 59.
Thank you.
So this is a letter from a consultant in clinical genetics at the Trust. And the letter mentions another doctor. I'm looking at the second paragraph on page 58. As we discussed, it is a very rare condition. Reports of other children with the same condition that have shown that it is quite variable, with some children living for many years, but others sadly having a short lifespan. And then the clinicians mentioned, talked about different options for treatments and explained that we cannot be sure of the best treatments for this condition because it is so rare. He has discussed Indy with colleagues around the country to share their experience, and different options can be tried for Indy to see what may work best for her. We say that this evidence, or this sort of evidence, which the Trust indicates, the clinician which is mentioned there is referred to as one of the people who is providing evidence to the court. But this sort of evidence, again, demonstrates that on the face of it, at least for some of the clinicians, the situation simply wasn't as bleak as it was presented by others. Now, admittedly, that letter was from the 13th of June, but that and the various comments from all sorts of experts which highlight the uncertainty, and even the experts.
I can understand that this letter indicates that there is uncertainty, and it clearly does. But it doesn't mean, I don't understand why this letter is evidence of someone having a less bleak view, sadly, of the prognosis or the likely outcome of Indy. I mean, as I understood the material that you gave us, and I did try and read as much of it as I could at the time, unless I've misread it, she has a unique, apparently, set of genetic mutations. It's the same condition, if you describe the condition as D2L2-hydroxyglutaric aciduria. But that doesn't mean that it's identical to the other sufferers of that condition. She has a unique set of genetic mutations, and so one doesn't. The fact that it's true that some of the other children with the same condition, at the level of generality of saying that's aciduria, have a different outcome over a period of a short while, doesn't mean that this doctor is saying that Indy will necessarily have that. That's not what this letter says at all.
I think what can be gleaned from this is that that we don't know.
Yes, but you said that this letter indicated that some people don't have as bleak a view. If that was what this letter did say, then I would understand also what you're trying to put to the court. But this letter doesn't say that. If I've misunderstood it, I'd really like to know. But I don't see the basis for saying that this letter means that someone has a less bleak view of Indy's prospects than is being put to the court.
What the letter says, what the letter doesn't say is Indy has a particularly severe form of this disease, and therefore, unfortunately, this falls on the very severe spectrum with a very negative prognosis. It's simply saying we're going to look at the treatment.
But there was evidence that did come before the court that said exactly that, wasn't
Yes,
there?
exactly.
But the evidence
it's mentioned in the judgment, I think, was it? That said the mutation was sadly absolutely the most severe end. I'm right, aren't I?
Well, my lady,
Do you want me to find it in the in the judgment?
I hesitate to. It's not my position to adduce medical evidence, but that, with respect, that isn't what the particular genetic analysis arguably did show.
Just remind me of the paragraph where that's dealt with, you, just so we're all looking at the same thing, would you? I can't put my hand to it at the moment.
Possibly paragraph 32, Roman 8a, which shows, which refers to the most severe end of this condition.
Oh, that's what I was thinking of, thank you.
Well,
that was your cross-examination from an academic argument.
Yes, and that again is an example of another matter, which simply which the court didn't have proper evidence on in order to reach that conclusion.
Well, sorry, what else was the diagnosis report from the geneticist then?
Well, the diagnosis, again, my lady, I hesitate to present medical evidence of which I'm certainly not an expert and I'm in no position to do so, but her diagnosis was that she was heterozygous for both of these gene mutations. And that means that each of those genes has got one deficiency inherited from each parent. The evidence such that it was, but it was in the form of a journal article which had undertaken a review of 26 different cases. The authors of the article weren't there to give evidence. I put this article to one of the witnesses. And what that article did say was that the most severe form of this disease was when the deficiencies were homozygous, where the faulty gene had been inherited from both parents. So this conclusion that this shows it's the most severe is, again, with respect, it's one which an expert in genetics, in this particular mitochondrial disease, may have had something else to say about. But the judge's conclusion, on the basis of cross-examination of a clinician who, Dr. E, who wasn't on his own admission an expert in this particular condition, then gave rise to this conclusion. But it's one in my submission which simply didn't follow from any of from the evidence that was before the court. It may be true, but it may also not be. And
the geneticist report was before the court, was it?
The journal article was.
No. Sorry, the geneticist's report.
Yes. So it's a 2-page report, and it says this condition's been identified, and it's in our supplemental bundle. I'm very grateful. Page 56 of the supplemental bundle.
Thank you.
Yeah. It's a very technical report, and it identifies what the particular problem is. Compound heterozygous for a likely pathogenic SL C25A1 missense variant and a likely pathogenic SL C25A1 deletion variant. So the evidence before the court was that for what this evidence is worth, it was just in the form of a journal article, admittedly, but it was that
you were asking the judge to treat it effectively as expert evidence.
I was using the journal article to examine the knowledge of Dr. E and the conclusions he came to, because one of the things that the journal article did show in a review of all the patients is that even in those who had severe versions of this disease, their life expectancy could stretch to a number of years. And that,
did they all have comorbidity of the type that this
Well-
child had? I mean, were we comparing like and like, or was the journal article specifically just dealing with poor, unfortunate babies that had D2L2?
my lady, some of the comorbidities are likely to be, and again, I hesitate to make any dogmatic statements, but some of the comorbidities may be intimately linked to the disease. What this condition does is it produces this glutaric acid in the body, which damages the brain before the child is born. So it's very likely, it would seem, but again, I say this with a certain amount of reticence, that the children who are affected with D2L2 are likely to have brain damage, and some of them probably very severe brain damage. At least one of the children mentioned in the article was in a PVS state and was being kept alive in a PVS state. So presumably there was extensive brain damage there. And if there is extensive brain damage, there is likely to be, one would imagine, hydrocephalus. But the article wasn't looking at the comorbidities. It was looking at these particular conditions. But again, if there had been an appropriate expert in this condition before the court, they would have been able to expand on that and would have been able to explain if this was a significance or not in this particular case. The causes of these saturation episodes, was this related to at all, was it contributed to by the heart condition or not? And if we look at that, the evidence on the page, there's a letter from one of the witnesses on page 88 of the supplemental bundle. This is the consultant intensivist who was cross-examined. This letter, the second paragraph on page 92, he says if it were successful, cardiac intervention would reduce the degree of desaturations due to her cardiac problems. Now, it's fair to say that subsequently he took a bleaker view and didn't believe that there was that the interventions should be performed. But there is evidence of that nature that was before the court, which was suggesting that it could help. And that's why it would have been immensely useful to have been able to have a pediatric cardiologist present, or to be able to understand why the teams from the other hospitals didn't think that, contrary to what the suggestion was made by various clinicians, why in fact it wouldn't have helped the desaturations. But that was an important point as well.
Thank you.
I'm going to conclude this ground just by saying that it's, just to sum up, that the court wrongly directed itself as to the anxious scrutiny requirement and informed its determination with large amounts of hearsay evidence, which was inappropriate in the circumstances, and this is in the circumstances of a very serious decision which the court was being asked to make. It was inappropriate to place much or any weight of it on it. And this was also arguably compounded by treating the evidence of the four witnesses essentially as expert evidence rather than evidence of fact. And as such, it wasn't possible to discharge the anxious scrutiny obligation on the court when coming to its assessment. In addition, or in the alternative, the evidence of the four witnesses, which was the only medical evidence directly before the court, we say was insufficient to enable the court properly to apply the anxious scrutiny obligation, and therefore to displace the strong presumption in favour of preserving life. And the court misdirected itself in holding otherwise. Which brings us on to the second ground of appeal.
And that's largely consumed into ground one, isn't it?
The second ground.
Yeah.
It is. There's a lot of overlap. But the difference is this, that the difference is that under ground two, the problem isn't the evidence that was before the court. Ground one is saying that the evidence before the court was not of a sufficient quality, or didn't satisfy the procedural requirements to enable it to be treated as sufficient quality, or it didn't cover the necessary expertise to enable the court properly to discharge its function. Ground two is saying that there was a procedural breach of the father's rights to equality of arms and to be able to be on a fair footing with the trust. And just to be clear, this argument is pursued under both the common law fairness requirement and under Article 6. But it's under Article 6 that there is a body of case law from the Strasbourg Court that I'd like to look at very, very quickly, just to illustrate what the requirement is under Article 6. The first case is, I'm going to take this very quickly, but if we need to look at them in any great detail, we can. But the first case is Regner and the Czech Republic, which is a Grand Chamber decision from 2017, and it's tab 26, page 626 of the authorities bundle. And the only proposition that I take from that is paragraph 146 of the case. And I mention this because it is a Grand Chamber decision. And it says this: the court reiterates that the adversarial principle and the principle of equality of arms, which are closely linked, are fundamental components of the concept of a fair hearing within the meaning of Article 6.1 of the Convention. They require a fair balance between the parties. Each party must be afforded a reasonable opportunity to present his case under conditions that do not place him at a substantial disadvantage vis-à-vis his opponent or opponents.
I'm sorry, you've lost me in the bundle tab.
So it's tab 26 of the authorities bundle. It's the last of the authorities.
Although I think I didn't catch the page number.
And it's
761.
And it's 761, paragraph 146. And this is a passage which is repeated in other cases, and I'm not going to repeat, but this is, I mention it because this is an endorsement from, a recent endorsement from the Grand Chamber of that principle. The next case that I considered was a case called Stoimanov and Macedonia, which was a prosecution for possession of opium. And this is on page 600, the authorities bundle. And the defence, there were convictions for possession of opium, what the applicants call poppy tar, was that because this had been stored for decades, it had been stored since the Second World War, it was likely that this opium had completely degenerated and that there wasn't any active ingredient, so that they shouldn't have been convicted. And the state was relying on expert report undertaken by the state themselves. And we see at paragraph 41 that same passage we saw in the Regner case. And then in 42, the court says this: the court finds that this principle was not complied with in the instant case, the equality, the fair balance principle, as the applicant's repeated request for an alternative expert examination was refused. So a requirement in these proceedings for people to be allowed to have their own expert. The next case is Eggersdotter in Iceland, which, page 615 of the authorities bundle. And this was a case of a child who had been born with severe disability, and an initial judgment for negligence had been against the hospital, had been overturned by the Supreme Court, who had commissioned its own evidence independently of the parties. And what the court said in that case, in paragraph 47 and 49, we see that the court recognises that the lack of neutrality on the part of a court-appointed expert may in certain circumstances give rise to a breach of the principle of equality of arms inherent in the concept of a fair trial, and references made to other cases. And there the concern is that this state body from whom they commissioned the opinion was one whose might have not been seen to be independent of the hospital hospital concerned, because some of the people who had provided this evidence, who were on this board, were employed by the hospital, albeit in a different department. But the court was saying that there's, in that situation, where the experts providing the evidence are employed by the same employer as one of the parties in the case, there are concerns raised under Article 6 if the party isn't able to have their own possibility to challenge that.
Thank you.
The next case, and just briefly look at I think 3 more cases, but Bajic in Croatia, on page 635. This is an important case. This was a case which involved death after abdominal surgery, and there was accusations of medical negligence, and there were also domestic criminal proceedings. But the problem is that some of the witnesses involved knew the doctor, who was a well-known doctor in the country, apparently, and had had dealings with him, or were his ex-students or connected with the doctor. And what this case established, and the paragraphs I'd refer the court to are paragraphs 89, 90, 92, and 95. But again, the requirement for independent experts, and we see in 92 that this was a case brought under Article 2, but what the court is saying is that in cases which involve life or death, that positive procedural obligations under Article 2 arise, which require the court to ensure that there's independence of the experts. We can see this in paragraph 95. In this respect, the court would reiterate that one of the fundamental aspects of the procedural guarantees enjoyed by Article 2 of the Convention is that proceedings capable of determining the cause of death of patients in the care of medical professionals must be conducted with sufficient care so as to ensure the independence of the findings of the experts involved. The requirement of independence is particularly important when obtaining medical reports from expert witnesses, who must have formal and de facto independence from those implicated in the events. Now, obviously, there's no implication, there are no events here, but by parity of reasoning, we have a situation where trust has brought proceedings and is putting forward a certain case. And the evidence relied upon, principally by the court in reaching that determination, is one which isn't independent of the trust, and understandably so in these sort of cases. It's inevitable and it's proper that the treating clinicians should explain, and they need to explain what's happening. But it's also proper, and this is unnecessary, we say under Article 6, that the parents are given a proper opportunity where there is reliance on non-independent experts, for the parents also to be able to produce their own evidence, and that would legitimately, properly take the form of an independent expert. There's a similar case, Bonisch in Austria, which is on page 504 of the authorities bundle. And this was a case involving prosecution for someone who had a business smoking meat, but his particular technique that he was using left some contamination in the toxic substances in the meat, in the smoked meat product. He was prosecuted for food safety violations, and the question was who conducted these examinations on the food and what reliance could be placed on it, and the court did find that there was a violation, and again the father, the applicant in that case had managed to get an expert, but the expert wasn't treated for various reasons in the same way as the court expert was treated, and he was treated as a mere witness, it is said, and he didn't have the same sort of rights as the court did in that case. But one of the points the court picks up on is at paragraph 34, where it says, in addition, as the applicant experienced in his case, there was little opportunity for the defence to obtain the appointment of a counter-expert. So there are cases where Article 6 requires someone to be able to appoint a counter-expert, and that is the case in normal civil litigation, that people are able to, they're not happy with an expert, to apply to have a counter-expert. But here we didn't have effectively any experts, and certainly the father didn't have any ability to appoint any of his own. And finally, the case of Mantovelli and France, at page 519, was a case involving what would have seemed to have been a relatively minor operation for Whitlow, but which led to all sorts of complications. And the girl patient died following an infection and apparent liver failure. And there was a suspicion that the anaesthetic that was used was responsible because she'd had to have so many of these operations. And the mother said this, she believed that this had led to an accumulation of this anaesthetic and had led to the liver danger. And the court in that case, the domestic courts, had said no. And we see at paragraph 33, the court notes that one of the elements of a fair hearing within the meaning of Article 6, paragraph 1 is the right to adversarial proceedings. Each party must in principle have the opportunity not only to make known any evidence needed for his claims to succeed, but also to have the knowledge of and comment on all evidence adduced or observations filed with a view to influencing the court's decision. And then at 36, we see the court looking at the nature of the evidence. And it's observing that the evidence pertained to a technical field, which was not within the judge's knowledge. So even though the court's not bound by the expert's finding, the report was likely to have a preponderant influence on the assessment of the facts of that court. Under such circumstances, in the light also of the administrative court's refusal of their application for a fresh expert report at the first instance and on appeal, Mr. and Mrs. Mantovelli could only have expressed their views effectively before the expert report was lodged. No practical difficulty stood in the way of their being associated in the process of producing the report, as it consisted in interviewing witnesses and examining documents, yet they were prevented from participating in the interviews, although the 5 people interviewed by the expert were employed by the CHRN and included the surgeon who performed the last operation on Miss Mantovelli and the anaesthetist. So the applicants were therefore not able to cross-examine these 5 people who could reasonably been expected to give evidence along the same lines as the CHRN, the opposing side of the proceedings. Mr. and Mrs. Mantovelli were thus not able to comment effectively on the main piece of evidence. Now, there was an exclusion from them in the preparation of this evidence, but we say that in this case, the same principle applies, that the father wasn't effectively able to cross-examine because he didn't have any medical evidence of his own which he could have relied on. In a situation where there isn't any opposing medical evidence. Now, it must be said at the outset that it is of course possible that the father, had he obtained his own expert independent evidence, that evidence might have aligned with the hospital. And that's why I opened my submissions by saying, Mr. Justice Beale may well have reached the right result, but we don't know. And if that had been the case, perhaps there wouldn't have been a need for any litigation. But the reality is that he wasn't able to instruct his own experts. He wasn't able to assess whether what he was being told by the hospital clinicians was true or not. And it became effectively impossible to challenge the evidence presented by the hospital. And for those reasons, we say that in conclusion to this ground two, that the requirement of equality of arms applies to expert evidence in all kinds of proceedings, but most particularly to medical evidence, which is likely to have a determinative influence on the court because the court isn't an expert on these matters and has to rely on the experts. The state can comply with this Article 6 requirement in two ways. It can either A, give all parties an equal opportunity to obtain and present expert evidence, and that's what usually happens in these sort of cases, or B, the court can rely on a neutral expert who is both formally, and this is important, as the case law from Strasbourg requires, is both formally and de facto independent of all the parties. But in the present case, neither of these permissible routes were adopted. Only the trust had the possibility to present evidence, and no expert of any sort was appointed by the court. And so, where neither of these routes were adopted, we say there is a breach of Article 6.1, and also, in a life or death case, also of the positive procedural obligations under Article 2. My lady, my lord, I will deal very, very briefly with the third ground of appeal. It's set out in the skeleton argument. The trust has responded by relying on two cases. One is Court of Appeal decision in the case of Dance and Bart's Health NHS Trust, which concerned the domestic enforceability of interim measures under the optional protocol to the UN Convention on the Rights of Persons with Disability. But what we say is that whether or not the courts have an obligation, and the courts have said that they don't have an obligation, to enforce interim measures made under an unincorporated treaty. We say this says nothing about the interpretative force of the treaty in relation to convention rights, in this case to Article 2 of the ECHR. And the point being this, whereas we can't rely on the convention directly to enforce any rights, what the convention's important in order to look at is to interpret the scope of Article 2, and that the court can legitimately and should legitimately do. And I rely on one authority that's mentioned in the skeleton argument, and one authority which I handed to my learned friends at the outset of the hearing, which was also sent in electronic format to the court, but I have paper copies if necessary, and that's the case of Guberina and Austria. But before we get to Croatia, before we get to the case of Guberina, I just wanted to mention quickly the other case that the Trust relies on against our reliance on the Convention on the Unincorporated International Law, and that's the Supreme Court case of R on the application of SCCB and 8 children. And this case I think it's in the Trust's Authority Bundle.
Trust's Authority Bundle.
Speaking for myself, I've only got one authorities bundle, but it's got that case in it at tab 20.
Exactly.
I'd ought to look at paragraph 80 of that judgment, which where Lord Reid recognises that unincorporated treaties, whilst not enforceable domestically, can nonetheless constitute evidence of a European consensus, or at least of relevant developments or evolving principles which can inform the interpretation of the Convention, the width of the national margin of appreciation, and the Court's assessment of proportionality. And that same sort of principle we can see in the case of Bubarina and Croatia in paragraph 92, where the judgment of the court says this: moreover, the court notes that by adhering to the requirements set out in the CRPD, the respondent state undertook to take its relevant principles into consideration, such as reasonable accommodation, accessibility, and non-discrimination against persons with disabilities, with regard to their full and equal participation in all aspects of social life. And in this sphere, the domestic authorities have, as asserted by the government, implemented certain relevant measures. In the case in question, however, the relevant domestic authorities gave no consideration to these international obligations, which the state has undertaken to respect. So,
I'm sorry, which paragraph was it?
92,
92.
of Bubarina. So it's, I hope, a non-controversial principle. It's not that we can rely directly on the unincorporated treaty, but it's that we can, and the court must, rely on a treaty and on the obligations that the state has assumed in order to interpret other obligations that it has. And in this case, it's to interpret the scope of Article 2. And it's in that optic that the rest of the submissions are made. My lady, my lord, those are my submissions.
Thank you. I think we're going to rise for a few minutes, please.